Hello friends, in the series on the income tax cases, today we will discuss an issue that if an assessee is incorporated in Spain and is involved in the telecommunication services and the assessee receives some interconnection charges from the telecommunication operators from India, then whether this interconnection charges received by the assessee will be taxable as royalty and fees for technical services in the hands of the service provider, that is the assessee in the present case. The issue has been decided by Honorable ITAT Bangalore, ITAT B bench in the case of Telefonica Depreciation ESPANA SA versus Assistant Commissioner of Income Tax International Taxation. This case has been reported in 118 ITR Tribunal at page number 302 and the date of the judgment is 10th August 2023. And the date of the judgment is 10th August 2023. Section 9 subsection 1 clause 6 talks about royalty and section 9 subsection 1 clause 7 talks about fees for technical services. In the present case, the assessee is a telecommunication company incorporated in Spain and engaged in rendering the telecommunication services, interconnection services and internet services. And during the relevant assessment year, the company provided interconnection charges to the various telecommunication operator companies in India. The assessee was of the view that since the assessee do not have any permanent establishment in India, so the assessee income by way of interconnection charges is not taxable as business income in India. And at the same time, the amount which is received in the form of interconnection charges does not come as per the definition of royalty under section 9 subsection 1 clause C and fees for technical services under section 9 subsection 1 clause 7 read with article 13 sub article 3 of the double taxation avoidance agreement between India and Spain. So that amount is not taxable as royalty and fees for technical services also. But when the assessment proceedings were going on, the assessing officer was of the view that this amount is taxable as royalty and fees for technical services, and it was also upheld by the dispute resolution panel. So the additions were made accordingly. The assessee moved to the tribunal, and when this matter was heard by the tribunal said that in the present case there is no transfer of intellectual property rights to the service recipient. The tribunal also said that in the present case no exclusive rights have been granted by the assessee to the service recipient. The tribunal said that no exclusive rights have been given as per 9 subsection 1 clause 6 to be termed it as a royalty. The tribunal further said that recipient was allowed to use the services of the equipment and does not have any right to use the equipment as per the definition of royalty which is given in article 13 sub article 3 of the double taxation avoidance agreement. The tribunal was of the view that in the present case, as per the facts and circumstances of the case, at any point of time, no physical custody was given to the recipient of services, and the process of providing the services in the present case is not a secret process and it is a standardized process, so it cannot be termed as royalty and fees for technical services. So whatever the additions were made by the learned assessing officer in the form of royalty and fees for technical services for interconnection charges were deleted by the Honorable Tribunal. At the end of this video, once again I am repeating the name of the case. The name of the case is Telefonica Depreciation ESPANA SA versus Assistant Deputy Commissioner of Income Tax International Taxation, and this case has been reported in 118 ITR Tribunal at page number 302. The date of the judgment is 10th August 2023. Thank you, friends.